Don't feel the obligation to dump assets into your children's laps when you pass away. And I don't care if your children are 50 years old. You just should recognize that you can do so much better by having it retained in the trust. You can give your children creditor protection. You can give them spousal protection from divorce and other such things. Even, quite frankly, the assets that would otherwise have ended up in the estates of your children upon death. You can actually do better by putting your children in the position to where you assure that when they go into that marriage, that those assets are going to continue in the trust safely protected. I mean, they're in a place that is better than a Swiss vault.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by Tucker Allen, Attorney-CPA Joe Cordell features guests each week to discuss prominent topics for those over 55. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of Life's Third Act. Today, I want to talk about blended families. We've touched on this topic before, but anytime you're doing any sort of planning for your future, especially estate planning, but also, quite frankly, marital planning, premarital, postmarital planning, the issue of blended families and how to deal with the various issues that often accompany that arrangement can and should be, quite frankly, one of the dominant considerations for planning for your own futures as well as the future of those you care about. So let me first start by, let's discuss a little bit about what is a blended family. A blended family is often used to refer to marriages in which there were children that predated the marriage, children of the wife, children of the husband, and then perhaps thereafter there become children of that marriage. So some have said his, hers, and ours. That, of course, is the stereotypical scenario, but blended families are really more complicated than that because at least the children within that marriage have some legal relationship. They're a stepchild. They're an actual biological child of perhaps the other parent who's not in the marriage, and they have legal rights associated with that. For the most part, there aren't legal rights that attach naturally, meaning through the laws of intestate succession, which are the laws governing what happens if you had no estate planning. What rights would the law give these other children? And for the most part, in Missouri at least, the law relating to stepchildren is not such a presumption. So for children that you want to enjoy the benefits of your largesse, of your estate, that you want to care for when you're gone, who do not have a biological relationship with you or were not born within the marriage, then you have to make plans. And a similar thing relates to children who were born outside the marriage, but for which there is no acknowledged legal relationship. That gets dicey because if you've acknowledged the child while you're alive, then there may be a presumption on the law that you intend to give to that child. But if you didn't acknowledge the child, then subject to a few technical circumstances, that person would not be able to be a beneficiary. There are some circumstances, though, where the father didn't know that the child was his, and there was no evidence of an intention to disregard the child. So I won't get into those details. Suffice it to say that children who are not born traditionally within a marriage will not enjoy probably the benefits that were intended for them, at least with confidence, without doing some sort of planning. I want to remind you that it's very important to us to get subscriptions. For you to press that like button is helpful, but the subscribe button is the most important thing to us. And, we don't sell a product on here. I mean, actually, the show is sponsored by Tucker Allen, so we do talk about Tucker Allen. But to be honest with you, the efforts that we put into this show is something that is of personal value to us more than monetary, quite frankly. We do love to do it because we think that we're being of great value to many of you. Let us know that. You like us? Yes. But the most important thing we look at is subscriptions. Adopted children, the law generally assigns the same rights and privileges as it would to biological children. So adoptive children, would be okay in terms if that were the only complication in your families. But typically, the way families come together today, or what we'll call those who we regard as our loved ones, often are not any longer within the confines of a marital relationship. I think that's a good observation to make generally in this discussion. There are people that we come to care about that mean a lot to us that may not be in a marital relationship at all, and that could apply to children or adults. So how do we provide for people who we really want to take care of? We want to assure that this happens. Well, the law is not going to help you if these relationships do not conform to a set of very strict rules. And it goes further than that. Not only will the law not help you, but the law may have created presumptions against your intention to help people that meant a lot to you, but for whom there's no legal recognition of a legal relationship. So in cases like that, how do you assure that these people that you care about will be taken care of? The law naturally operates on presumptions, and it has to, quite frankly. The law has to have kind of rules of thumb. And these rules of thumb say that where we run into something of uncertainty, where we think a will is not valid, where a provision in a will is unclear, circumstances where there's a challenge to a will, or whether there was undue influence, all the outcomes in those contests or disputes are affected by how the law would otherwise regard this claimant. And if they're outside any normal legal category, then they're at a disadvantage. And it could be worse. They could be in a particular legal category where it's clear that they are not to be the beneficiary unless you clearly express that that's your intention. So there are lots of reasons to think about how to deal with blended families and to recognize that it's very different from the assumptions that you have with a normal nuclear family. Those days in America are past. Family profiles don't conform to that scenario that existed largely in the 50s, I guess, 60s, and less so in the 70s, and less so for every decade thereafter. Now, what particularly confounds or exacerbates what is in and of itself a complicated situation is the potential interpersonal dynamics that accompany this relationship. So those of you who have lived in blended families, who have had exposure or relationships, friendships with people who are in blended families, you know that sometimes there are resentments. Sometimes there are, one set of children, for example, may resent another set of children. Or they may, quite frankly, appear to get along fine until one of the parents passes away and there's a dispute about inheritance, for example. And then all those things, those resentments that might have been there for a long time that have been pretty much simmering or maybe quiescent below the surface, suddenly they become visible, maybe in a volcanic way. But you don't know necessarily what all the children, for example, might think about other children. And maybe a child that's not within the marriage, but clearly a biological child, that child is especially justified perhaps in thinking that they were not the beneficiary for many years of the attention and whatnot of a parent, of a biological parent that perhaps other children were. So sometimes that's set up to create, this division. So it's often said that there's no war like a civil war, meaning, and our American history tells us that, But I would argue that there's no conflict, there's no litigation like intra-family conflict. And as somebody who practiced domestic relations for many years, I can tell you that that sort of conflict can often arise anytime there are disputes that on the surface may relate to one thing, but in fact there's something, many other layers. In divorce, it may appear that it's a dispute about custody. It may appear that it's a dispute about money or a house or other assets. But in reality, there are layers of conflict or complaints or whatever they might have been that accumulated over perhaps decades in a relationship. So often the conflict is not fueled by tangible things, and so that is the layer of concern that you have to place on top of the first discussion. One is, what is a blended family? Well, it's complicated. And it's complicated also from a very legal standpoint. And it's that complication, of course, is magnified by the fact that you're not there to explain what the issues are or to explain what your intentions were, perhaps. And so you're gone, and then that's when these wars, flare up, potentially. And then the additional layer, though, is the interpersonal relationships that sit on top of this already complicated thing. And you throw in the legal complexity to the interpersonal complexity, interpersonal relationships, and it's really an invitation to a lot of waste and a lot of bad feelings that may subsist for decades after you're gone, because this was not made clear. And these things often could have been handled much, much better. In fact, very smoothly, if done correctly, in most cases, not in every case. So I think I've kind of laid the foundation for this discussion. It really behooves anybody who is in a situation where there may be relationships that are not clear from a legal standpoint, that are not perhaps fully acknowledged by others within your familial circle. If that's your situation, whether it's a technical blended family or not, then you're in the situation where you have the sort of blended family problems. And that requires a different perspective when you think about estate planning. But I would argue a more urgent, certainly a more complicated, a more urgent scenario exists for you to do your estate planning and to do it correctly. So normally what we suggest, and what you've heard from the attorneys at Tucker Allen, is that most people need to have a living trust. Living trust is an alternative to running your things through your estate and through a will that assures a lot of delay and expense, and I won't make this show about that. But let's start with the idea that in a normal nuclear family scenario, you would have estate planning that consisted of a living trust, perhaps. We'll call it a revocable trust is what I mean. Coupled with a will that would be strictly for the purpose of pouring over any assets that went into your estate that you didn't intend to, pours them over into your trust. You would also have documents relating to care for you if something happened while you're alive suddenly, and we'll talk about that more in a few minutes, but those are a durable power of attorney and a durable power of attorney for health care. So how would this change regarding the centerpieces of your estate planning if you have a blended family? Well, there are various ways of approaching this, but as a former divorce lawyer, I have to go back a couple steps and first point out that in a situation where parties, the spouses are coming into it at a point perhaps 10 to 15 years into their careers, at a point where they've likely accumulated assets outside or before that relationship, where they have children, perhaps from their first marriage or earlier relationships, that in that situation, typically it's a good idea for both spouses to think about a premarital agreement. And this agreement is something that is an obligation perhaps less between you as individuals than on behalf of those that you care about, children from the prior marriage. It's one thing for somebody in midlife to go into a relationship without any sort of planning, without a prenuptial agreement, because they're just going to assume the risk. They feel that they're in love and they're confident in the relationship, and they're going to assume the risk. And I completely get that. And I would be very slow to raise a hand to make a point. But it's a different discussion when you have children. Then it's less about the fact that you may want to undertake that risk, which again, I get why you want to treat marriage as something very special, and even entering into it in midlife when each of the parties have accumulated a significant amount of assets, you want to just go into it boldly and with faith and confidence in your spouse-to-be. I get that completely. But whenever there's a significant amount of assets that have been accumulated and you each have children from prior marriage, or even one of you does, then it is a little bit of a different discussion. Then you're undertaking a step on behalf of them too. And then I would argue it behooves you to pause and think about, to what extent does this make sense? And it may make sense, but often, some sort of prenuptial agreement is appropriate. Not so much because you doubt the marriage, but you feel like you cannot undertake this inherently somewhat risky decision with disregard to the interest of your children. So if that's done, that was often the scenario where you deal with an allocation of assets in the event of someone's death. So a good prenuptial agreement doesn't simply make provision for divorce. Matter of fact, maybe that's the best way to think about it, is I'm not doing this because of a fear of divorce. I'm doing this because of the concern that one of us may pass away when these children are minors, or even when they're adults. It's often the same issues when your children are adults in this context. So under those circumstances, you can go ahead and incorporate the estate planning in the prenuptial agreement, and it can make things go much more smoothly. And that agreement would make a provision for the assets that you brought in to the marital estate. Those would be set up in a trust, a living trust, a revocable trust, and they would be administered according to the terms of your prenuptial agreement, or incidentally, it could be a postnuptial agreement. So a postnuptial agreement will be honored as well if the terms are reasonable. You need to hire an attorney. Be sure, incidentally, the other side has an attorney. There are some I's to dot and T's to cross if you're going to do a prenuptial agreement and have it hold up. So whether it's prenuptial or postnuptial, you want to be sure that you attend to the formalities of executing a document like that and have it hold up if challenged. And remember, that's the most crucial thing, is you may be gone when it's challenged, meaning you may have passed away, or if it's divorce, then there's going to be an invitation for the other side to challenge any weakness in the document at all. So prenuptial agreements do need to occur with certain formalities for you to be confident that they'll hold up. So you need to have a lawyer, and you need to be sure the other side has a lawyer. Don't let the other side wave their hand and say this isn't necessary. It's necessary for your document to be valid that they have a lawyer. So that's still, when you do it in that context, when you do the planning on the front end like that, still you're still having to attend to the details of estate planning. You're just addressing them kind of on the front end, which is a great idea. But even in the absence of that, you can go ahead after you're married and make decisions about how you're going to do your estate planning. You can create a document that memorializes that decision, call it a postnuptial agreement, and then you implement that postnuptial agreement by creating trusts. And this may sound a little complicated or expensive, but it doesn't have to be. As a matter of fact, if your estate's not that complicated and your plan is not that complicated, meaning what you want to happen and in what detail and what series of events, et cetera, then it could actually be fairly inexpensive to do it that way. You're still looking at several $1,000s when you do estate planning with trusts, and say you're middle class or above. Could be significantly more than that. But I don't want you to get caught up in that. I really feel strongly that when people think more about the cost of their estate planning than they do about a vacation, then something's wrong. Something is wrong with that. And I can tell you that for 8 out of 10 people, I think that that's a true statement. They will spend $3,000 to $5,000 to $10,000 on a big vacation, and the idea that they could spend that much money in estate planning is just totally unacceptable. So I'm not saying you'll spend $10,000. I don't want to run you off from this, but I do want to make the point that this is more important than your vacation. But once you create these trusts, then you have the assets already divided up through your agreement, and then each of you would by terms that are, prepared by your lawyer, you can have provisions where either of you would waive a claim to what's called an elective share. That's one of the issues that comes up when you're doing estate planning for blended families, where they're wanting to assets that predated the marriage, maybe even assets that accumulated during the marriage, to be divided up among their particular children or their particular loved ones, whether children or not. What can disrupt that if it's not planned for correctly is that under the law of Missouri, in virtually all states, there's a so-called elective share, and at least common law states. And Missouri is a common law state. So you have elective shares. So that means that a wife or a husband has the right to take against the will. And that means that they can claim, depending on the circumstances, 1/3 to 50% of the assets. They can just take against the will. So if you've created a will and says, I want all my assets to go to my children, they have the right to override that. That's just a fact of the law of Missouri and the fact of any common law state. So how do you get around that? Well, you can a properly prepared postnuptial agreement, prenuptial agreement, properly prepared estate planning, parties can waive that. So, and it typically is waived, but it has to be done correctly. Otherwise, it won't be valid, and you can still have a surviving spouse to exercise that. And the temptation is understandable. It's not that they're being devious. It's not that they are somehow defrauding the marital estate. They feel perhaps that their children didn't get their share. I've heard that many times. Some people feel that their children need it more. Sometimes there's simply resentments in relationships. Remember, often the kids are adults at this time. So we're not talking about a 6-year-old child that's made, the stepmom or stepdad angry. We're talking about a 30-year-old or 35 or 40-year-old son or daughter that's made, the surviving spouse, in this case, angry or resentful. So those things just often happen, and sometimes they don't flare up or come to the surface. As I said earlier, they don't come up until at the time of the event. So the estate planning has to be done with care to assure that the assets that you want are your share, we'll call it, and often that's the assets you came into the marriage with, coupled with perhaps the assets you accumulated during the course of the marriage, that you would be able to pass those along to your children in whole, ideally. And the primary problem is assuring that the elective share doesn't become a problem. And also there's the issue about, did you properly express your intention so that you avoided the possibility of a challenge? I can tell you, blended families are the most notorious scenarios where you end up in will contests, where you end up in probate court litigation. Often the claim is that there was undue influence by perhaps a step-sibling or a half-sibling or an adoptive child. I mean, these children are just more vulnerable. And keep in mind, though we're calling them children, generally, statistically, when this happens, they're adults. You can see why the dynamics are such that the potential for conflict is so much greater, and that potential is realized for many families. So how do you head off what is this great potential for conflict that I've been talking about today? You can't head it off completely, but you can insulate your plan. You can insulate your plan by preparing it with an eye to this potential conflict. So you do it in a way as if you fully anticipate certain types of challenges to come. Some of those challenges you will be able to point your finger to and say, I think that this is likely to happen. or I think that. But others you can't. So you have to plan certainly for the ones you anticipate. And then just as to all the others, you have to be sure you've done everything right in terms of just general protection and assume that it will hold up. And it generally will. So what are those general things you can do? Well, first, let's talk about the specific things. As to the specific things, you build into the plan the sort of barriers that you need to build. One could be that there's a forfeiture clause, an in terrorem clause, it's sometimes called. And these, the courts don't like them. A provision that says where somebody challenges the will, then they forfeit their interest. But if it's drafted correctly and reasonably, in other words, not just in terms to where if somebody had a legitimate claim, they're still barred from raising it. Say that if they thought that the will was not valid for some reason. Generally, courts think that's unreasonable. Generally, courts think that somebody should have the right to assert that a will was not correctly executed or that maybe there was fraud. So most states take the position that if someone raises a challenge like that and it turns out to have merit, then they don't forfeit their interest. And many other courts have said, and even in Missouri, the opinions aren't consistent. What is consistent for the most part in Missouri is the notion that if somebody is being reasonable in raising a concern that is a matter of public policy concern, like fraud and things like that, then the court doesn't want a provision that essentially forecloses somebody from challenging it. Because if you think about it for a moment, it's the perfect way to commit this crime. If you're a person who has had undue influence or defrauded this elderly guy, an elderly parent, into giving you all the money, then you would, in the process of setting this up, you'd also say to this elderly person, oh, by the way, put in an in terrorem clause. So you can see that it only makes sense that courts will allow someone to challenge for certain things. So when you create these provisions, as you should, if you anticipate this sort of conflict, I think it's perfectly reasonable. But you want to be sure that these provisions don't reach too far. That the legitimate things they can raise, but anything beyond that, it'll close that door. So it doesn't really eliminate usually any type of challenge. You're not going to accomplish that in most courts, but you will accomplish any frivolous challenge. Anything that even is of dubious merit is probably going to be ruled in your favor if you have a strong in terrorem clause or a clear in terrorem clause. So that's one thing you can do. Another thing that it doesn't sound like much to some, but I'm telling you is probably the single most important thing you could do is to sit down in advance. I almost uttered the sentence, in advance of your death. But let's just to say that I don't have confidence you can speak from the grave. So it must be before you pass. But nobody wants to do this meeting. The reason they don't is because it's not a pleasant meeting. But the idea of getting together with your children, and maybe not in the same room, matter of fact, probably not. I've seen it done both ways. But to sit down with each and to be clear that they understand why you're doing. They don't have to be happy about it. That's probably asking too much. There's probably somebody who's not going to be happy, if not all of them. But at least they know that you had reasons in your mind, that you explained to them why you're doing this. There's no longer this continual suspicion and speculation about what you believed at the time you died, and especially by the kids who are not in regular contact with you toward the end. Those are the ones that really become fraught for conflict. Is they imagine, they speculate, sometimes correctly, but usually not. They speculate that the child or the person, whoever it was that was with you every day, had created this false picture, had manipulated their attitude toward you, et cetera, and they become convinced of this, and often that's what ultimately accounts for litigation in probate court in many cases. So to the extent that you've actually sat down with them, several years perhaps before your death, but you've sat down with them and you've said, look, this is why I'm doing what I'm doing, at least it's very difficult for them to manufacture this theory that what you thought was entirely something that was crafted by another person. It was undue influence or fraud. So that's probably the single most important thing you can do. Another thing you can do, though, is to bulletproof your plan as much as you can. Make it clear. Be sure there's no ambiguities. You have to be sure, for example, if you're going to have an interim clause, a clause where there's a forfeiture if they a no contest clause. If you're going to have that, incidentally, there has to be incentive for someone not to attack it. I've actually seen this. I've had wills where they had no contest clauses, and the people most likely to contest it weren't getting anything anyway, and they wouldn't have under the intestacy laws if the will were thrown out. So you have to be sure that you give everybody, especially the people that you think are most inclined to challenge you, give them something so that if you create a no contest clause, then you've given them something to lose. And if they have something to lose, then they're far more likely to challenge this. You eliminate the allegations of fraud for the most part, I think, with those interpersonal meetings where you've made provision. Another thing is, how do you execute it? There are things that your lawyer can go over with you, your estate planning lawyer, to assure that what you said in the will was what you intended. Sometimes that's done through a videotape session. Not always is that a good idea. If you look frail or uncertain or unclear, then sometimes a videotape of what you're doing and why you want it is actually harmful to your case because you don't look clear. But more often than not, that would be helpful. But other times, it's simply a matter of having others visit with you who are prepared to testify later as to what you said about why you're doing it. And this is apart from the meeting with the family. And then the formalities of execution. Those have to be fastidiously complied with. Wills are strange like this. Now, trusts, not so much. But wills are like that. Another thing that when you're thinking about the trust is that if the more assets you run through your trust directly as opposed to the indirect route of going into your will, into probate, then into your trust, also minimizes the risk of any sort of challenge. Now, it's true that some people think that when you put things in a trust, a revocable trust in this case, that you've eliminated the risk of a probate challenge. That's not entirely true, actually, but it is true that it's much less likely to happen. And the reason it's much less likely to happen is that to the extent that you've put the assets in a structure such as a trust and you're living with it on a daily basis, meaning you're living out the things that you've said in this document, and you're probably doing it over a period of years, the probability that this was somehow slipped under your nose and you're given a pen and didn't know what you were signing is very low. Not to mention, the kids they're not seeing the distribution when you pass away. So it's true that the kids are not, by virtue of that, do not themselves know the contents unless you've chosen to give it to them. You have no obligation to do that while you're alive. But at least they know it's in a trust. They know there are terms of the trust. They know that as far as it is now that you're participating in the trust, actively engaged. So you do hear of trust challenges, but I will tell you it's much less common than there are to wills. Now, still, I know that some of the assets you will run through the will on their way to the trust for various reasons. Some assets you didn't know about, some assets you wanted to get maybe a stepped-up basis. So there may be some reasons that you'll have some things take the indirect route to end up in your trust. But for the most part, your assets should take a direct route. It doesn't mean that they have to be in there prior to your death, but like you can have POD clauses, payable on death, transfer on death clauses. Virtually all assets can go directly into your trust. They don't have to go through probate, even if you don't put them in immediately when you create the trust. And it's not uncommon for lawyers to see advantages to certain assets to say, well, we'll leave it outside your trust while you're alive and healthy, and then when you pass away, we'll have a transfer on death clause. Doesn't go into the will, doesn't go into probate, but it goes directly into the trust the moment you pass away. In real estate, you can do that. You have beneficiary deeds. So there's no reason that you have to run a significant amount or any assets technically through your will. But I just know that many clients, for various reasons, and often not good reasons, but they'll have some assets that go through their will, but they know their will is a pour-over will, so their intention is for it to be dumped into the trust. Just keep in mind, though, that they're more vulnerable to challenge when it goes through the will. But as a practical matter, things can be challenged with a trust. But I think I've persuaded you that it's less common for it to happen in that fashion. So another thing let me add is, and I add this all the time when I'm talking about this subject, don't feel the obligation to dump assets into your children's laps when you pass away. And I don't care if your children are 50 years old. You just should recognize that you can do so much better by having it retained in the trust. You can give your children creditor protection. You can give them spousal protection from divorce and other such things. Even, quite frankly, the assets that would otherwise have ended up in the estates of your children upon death. So we were talking about that situation where you have a blended family, you marry, you have to think about the fact that now that you're marrying, these assets that you had before could be lost or could become marital assets and ultimately be claimed through, if not prior through a divorce, could be claimed at death through an elective share provision or some other claim. So you can actually do better by putting your children in the position to where you assure that when they go into that marriage, that those assets are going to continue in the trust safely protected. I mean, they're in a place that is better than a Swiss vault because this is a trust that was created by their father or their grandfather or grandmother. I mean, this was something where there were terms provided for payment of money when and if or as needed. It's a discretionary trust. The trustee can meet all of your children's needs, all their reasonable needs. The trustee can manage that. At the same time, whatever is not needed is safely protected. So if you go forward and think about all these things we've talked about now, well, if you do your job correctly, as far as your children and grandchildren go, there may not be such a problem because you have already protected them from these, what I would regard as far and away the primary risks associated with owning assets in this world. The risks associated with marriage and creditor risks and the risks at death. I mean, when you wipe out those claimants, then you've made your assets as safe as they could possibly be in this world. So you can do that for your children. You can do that for your grandchildren. You can do it for them better than you can do it for yourself. Now, I've described how you can protect yourself, and those are wonderful ways to do that. And you can even create an irrevocable trust to give yourself creditor protection. So there are things you can do, but I will still tell you that those things are never as complete and as comprehensive as they are if you create the trust for the benefit of someone else. The law treats it differently. And the benefits that will be afforded your children and grandchildren, even if you're not rich. Remember, you don't have to be rich. Money accumulates over time. The protection you can afford them is something that they simply could not give themselves. They don't have the legal rights to give it, just like you don't have the legal rights to protect yourself that fully right now. But you can do it for them. So keep that in mind as a strong motivation to do your estate planning, and in blended families especially. To the outside world, especially where there are children that are outside that marriage, the outside world doesn't know what your set of priorities will be in the same way that it does in that June and Ward Cleaver scenario from the 50s. Then the outside world would look in and say, there are these two children, these two parents. The legislature would assume a certain allocation in a certain manner that 80% plus of the time would be correct. But in a blended family scenario where you have children that are not in that marriage, you have children that are not even have legal status yet, you have stepchildren, you have half-children. For someone to look in and know exactly how you wanted to treat those various children, and even that, in this case, I'll presume a second wife, that all those assumptions may be different. They may be the same, but they may be different, and often they are. So for you to rely on the legislature to place laws as a safety net below you in the event that you fail to plan correctly, and they can rush in the case of intestacy, for example. In other words, your estate planning either doesn't exist or it's not valid. Then they can come in and by their assumptions, their profile, it turns out that that's pretty much on the mark for you. Well, that's not, in your case, is my argument. I mean, my argument is that that was something that we shedded 30 years ago. I mean, now legislative assumptions are not reliable because profiles are so varied, and it's difficult for us to know what your particular priorities will be for the people you love. And they may not just be your children. It's a complicated world, and it's not gotten any simpler. Before I wrap up here, let me also say what it follows on the heels naturally of what we've discussed already, and that's that, remember, you may not be competent up to the moment you die. Statistically, there's an increasing chance. I used to know the number. I don't know what the number is now, but 10 years ago, it was like there was a 23% chance you'd be incompetent when you passed away. Now I'm sure it's a higher percentage. So what that means is that there's going to be a period of time when somebody else is going to be in charge of your stuff. And you want to be able to decide the terms that they operate under and who it is. And the good news is you can. And it's real cheap to do that. Matter of fact, some people will simply order a form, and maybe the form is better than nothing. So I don't wholly disagree with that. But the point is, it's such an immense risk, and it's such a substantial probability that you're going to find yourself with this person in charge that I don't think you want to find a form somewhere and sign it and say done. I think that's something of such magnitude. The person who has the power to run your life, they're going to make decisions about your health care. This is the durable power of attorney for health care. They're going to make decisions about your finances, your legal matters. Now, they can't change your will, so there are some limitations under Missouri law, but there aren't many. There aren't many limitations. They can pretty much do what they want with your stuff. Now, they're supposed to do it for you, but who's watching? So, it's a scary thing. And if you do nothing, then there has to be a hearing in front of a judge. Everybody wants to do it, joins in the fray. And after they've spent some significant portion of your life's work, then the judge will appoint somebody. It may be none of those people. And then they have to report to the judge. You're paying for that too. So you don't want that, but I'm telling you, that is what you have right now if you've not created this document. The good news is you can create this document, something you can have done in a week, and then you'll know that at least if you're driving a car and you have a wreck today, or you have a stroke, or whatever physiological or other event that may happen, you're good. You're good, because all those things that need to be done, need to be taken care of, you've empowered someone legally. They have the authority to go out and do the things that you want done, because in that document, you've indicated what powers you want them to have and what you don't want them to have. And that's an important thing too. So do you want to create somebody that has omnipotence over your life and your things? Or do you want to say, well, I want this to be a more crafted instrument where I want them to have authority over some things, but some things I know are already okay, so I don't want them tampering with that. Well, you can make those decisions. Some of you may be thinking, oh, it's okay, my wife will do that. Well, for one thing, your wife can't do that until she's legally empowered to do it, so that still puts you in front of the judge, and the judge may not want her to do it, or him. Statistically, it'll be her. So in that case, what do you do? Well, you have to recognize that your spouse is probably close to your age. Now, unless she's 30 years younger, then I'd say you should be concerned for other reasons. But let's assume it's that you have a spouse that you've been married to for many years, you trust him or her completely. But the only problem is that they're old too. So for you to hang your hat on the idea that, gee, if I have a stroke or I become incompetent, then he or she can care for me is just a slender reed. It's something that it may be true the day you have a stroke, but it may not be true a week later. So you want to create a document where you list a series of choices. This is huge. I can't emphasize to you much how huge this is. For many people who are less concerned about their children in terms of their ability to support themselves or their inheritance, for many people, the most important thing is to be able to have some control over what happens to them for the balance of their lives. That's the priority for many people, believe it or not. And I understand that, depending on your situation with your kids or if you have kids. This is a document that's not expensive and it's not complicated, but you want it done. So I think if you've watched this show very much, you know how emphatically I feel about durable power of attorney and a durable power of attorney for healthcare is, there's no excuse for somebody not having those things in place. And the beautiful thing about it is when you have that in place, no judges, no courts, no attorney fees, no delay. That person is in power immediately to address your needs. Immediately. They can move money in your bank account that needs to be done to pay for transportation to a hospital, to whatever costs for loved ones that if you've authorized it, if they need to come to your care from another part of the world. I mean, these are things that you can have in place, and it's real easy to do. And it's incredible to me that as many people go out of this world, are in this world without that document. If they just go out of the world, again, it's not an issue. And some of us will pass that way. We'll be competent up to, an hours or so of our death. But you don't count on that, particularly when you have the capacity to keep us alive under, very vegetative conditions. And that's another thing, incidentally, you can address in this document. So I would say that if you have a blended family, one reason that I bring it up here as a little more urgent is that there is more potential for a conflict as to who's to have the authority to make that decision. So you want to head that off. And the way you head that off is appoint somebody now through a durable power of attorney. Don't have them in front of a judge, each with their own lawyers, 5 lawyers, their meters running at $350 an hour and court costs, and then having to reappear and report whoever's appointed, and probably is going to end up coming out of your pocket, not necessarily if you have that many fighting. But ultimately, whoever's appointed, you're going to be paying for that. So, it's just one of the facts of life that we have to accept in the modern world is we do have blended or non-traditional, maybe that's a better phrase, non-traditional families, and it behooves us to be a little more attentive to the potential issues that can arise in that scenario. And I've just, pointed out to you what some of the most vulnerable spots are. So in addition to the estate planning, remember that you need to have in place a durable power of attorney for health care and a durable power of attorney, the general power, which applies to legal and business. And those things can head off a lot of family conflict. So we could talk about more here. I hope this has been helpful. We certainly will come back and talk about blended families in the future, but I wanted to kind of hit on this topic specifically and call your attention to some of the issues to consider. This has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement, sponsored by Tucker Allen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit tuckerallen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.